let's raise the questions. End of the road, therefore, for sedition law or not? Will the government now act on its promise it has made to re-examine this law? Has the Supreme Court done what the executive failed to do? Big step forward for the country in the battle for free speech? Yes or no? Joining me now is Mahua Moitra. She's there as a Trinamool Congress MP, but importantly today as also one of the petitioners in this case. And Aryama Sundaram, senior lawyer, Supreme Court. Appreciate the two of you joining us. Mahua Moitra, do you see this as a victory today for free speech? Or do you believe it's only a temporary respite, given the fact the government has said it's re-examining the law? The law is still there, or is going to be there in the future if the government so chooses. How do you see today's order?
Look, Rajdeep, it's definitely a step in the right direction. And I would say it is a historic day because look what happened. 1962 was the last time that the Supreme Court examined this. The government says that this law is necessary and with reasonable restrictions. But in 1962, a 5-judge bench of the Supreme Court already laid down what it said were reasonable restrictions to the misuse of this law and said that imminent lawless action, incitement to violence for subverting government were the only times this law could be used. So mere criticism of the government and mere using constitutional means to protest or to dissent could not be termed as sedition. But we've seen in the last 5 to 7 years that obviously the 1962 judgment has been thrown out the window, and governments all over India, state and central governments, have used this law as a tool. In fact, the British used it to throttle Indian voices, and the Indian government, an elected Indian government, has done exactly the same thing. So it is important today that
may I add, Mahua, Mahua Moitra? No, ma'am, including state governments, because when it comes to free speech, you've seen even the Trinamool government has clamped down on those who have been critical of you.
Rajdeep, let me finish. Why are you getting so excited? Let me finish. Yes. Obviously, police is on list 2 in the constitution. Obviously, it's a state subject, so obviously state governments will do it more. That's pretty obvious. That's not the point. The point is because the law existed, there was room for people to misuse it. This law should not exist. And the most important thing here is that the government has come in and said, first the SG and the AG were on different platforms. The Attorney General was ready to argue. The Solicitor General says, please leave this. The court has no business looking into it. The government then comes in after 8 years of being in office and says, we will reconsider it. Please note, they use the word reconsider, not revoke. What is to stop this government, and we have seen this in the past, from their brute majority, from bringing in a revised version of this with amendments rather than revoking it, and amendments like silly ones like the one they put up in court, which is to say an officer of the rank of an SP or above can look into it on a case-by-case basis. That's just carte blanche to misuse it again. What the court has done, Gopal Shankar Narayanan, who was appearing for me in the case, put in a 1-page submission in which he said, let the central government go in and reconsider it. Beware, they have not even put in a timeline. So it might take months or years or whatever, and the government cannot place on affidavit what Parliament is going to do. The government cannot do that. So Parliament alone can legislate. Given that we do not know what timeline we are looking at, the Supreme Court has said that no new FIRs can be filed on sedition, and people who are in jail for sedition, people who have been arrested, have the right to recourse. In immediate recourse as in bail, and all chief secretaries, all senior police officers have been informed that this is the situation. So I think this is definitely a victory. Of course, this is, historic.
You know, it is historic, but I will just press you one more time before I turn to Aryama Sundaram, just to say this. Do you therefore concede at one level that the state governments, it is not just the Modi government's problem, it's also state governments across the country who have misused it? No, 1 minute. We've seen Uddhav Thackeray, government in Maharashtra used it against Navneet Rana, a political rival, for reciting Hanuman Chalisa. We saw last year how the Delhi police was used to arrest Disha Ravi, an environmental activist. We've seen in the context of free speech, misuse of other provisions by your government to arrest a cartoonist who was critical of Mamata Banerjee. My point is, if the attitude, the mindset of the state does not change, the police will be used as an instrument.
No, that's exactly why we need this law to go. And let me place on record, the cartoonist was arrested under 66A, which has now become infructuous, not under sedition. And West Bengal, since 2014, since our government came to power, has only 10 cases of sedition filed, which again, had this law not existed, should not have been filed. So there's no question that the state governments are using it, because obviously this is police is on list 2. So obviously state governments will use it. That's number one. It's not a question of, which pot is blacker than the other, or sort of, who's more to blame. The question is, when you have a law that has no place in a modern constitutional democracy like ours, the law needs to go. If the law exists, everyone is under temptation to use it. So the law is bad, and we need this law to go, which is exactly what the first step the Supreme Court has taken.